Ever heard the word probate and felt a little chill run down your spine? It sounds complex, scary, and expensive, right? Well, today, we're going to demystify it completely. I'm going to walk you through the entire probate court process, step by step, so you know exactly what to expect. By the end of this video, you'll feel way more confident about navigating it. So, why should you even care about probate? Here's the deal. When someone passes away, their assets can't just be handed over to their family. The legal system needs to make sure everything is done correctly. That's where probate comes in. It's the court-supervised process of validating a will, paying off debts, and distributing what's left to the rightful heirs. The problem is, this process isn't always quick or cheap. It can easily take 6 to 12 months, sometimes even longer, and legal and court fees can add up to thousands of dollars, eating away at the inheritance intended for your loved ones. Understanding how it works is your best defense. It allows you to plan ahead, either for your own estate or if you're an executor for someone else's. Knowledge helps you keep costs down, speed things up, and avoid nasty surprises for the family. So let's dive into the 7 key steps of the probate process. Step 1 is filing the petition. This is the official starting gun. The person named as the executor in the will, or another interested party if there's no will, takes the lead. They will file a document, usually called a petition for probate, with the probate court in the county where the deceased person lived. Along with this petition, they must submit an original certified copy of the death certificate and, if one exists, the original will. This initial filing gets the ball rolling and officially opens the probate case with the court. Step 2 is giving notice to heirs and creditors. Once the court accepts the petition, it's all about communication. The court issues formal legal notices to all potential heirs and beneficiaries listed in the will. This gives them a chance to review the will and, if they believe there's a problem, to contest it. At the same time, a notice is typically published in a local newspaper to alert any potential creditors. This is the official announcement that the estate is being settled, and creditors usually have a specific window, often around 30 to 45 days, to come forward and file a claim for any money they are owed. If they miss this deadline, they might be out of luck. This step is crucial for ensuring everyone with a legal interest in the estate is properly informed. Step 3 is the official appointment of the executor or administrator. After the notice period, the judge holds a hearing. Assuming there are no major objections or contests to the will, the judge will officially appoint the person responsible for managing the estate. If there is a will that names an executor, the judge issues a document called letters testamentary. This document is like a golden ticket. It grants the executor the legal authority to act on behalf of the estate. If the person died without a will, a situation known as intestate, the court appoints an administrator and issues letters of administration. Both documents serve the same purpose. They empower someone to start gathering assets, opening estate bank accounts, and managing the decedent's financial affairs. Without these letters, banks and other financial institutions won't talk to you. Now for Step 4, inventory and appraisal of assets. This is where the real accounting begins. The executor has a big job. They must find, identify, and create a detailed list of everything the deceased person owned. This inventory includes all types of assets, real estate, like a house or land, bank accounts, investment portfolios, cars, valuable jewelry, and other personal property. It's like a massive treasure hunt. For certain assets, like real estate or rare collectibles, a simple estimate isn't enough. The executor needs to hire a professional appraiser to determine their fair market value as of the date of death. This detailed inventory and appraisal report is then filed with the court, usually within 90 days of the executor's appointment, though this deadline can vary by state. This creates a clear, official record of the estate's total worth. Step 5 is a big one, paying the estate's debts and taxes. An estate is treated like its own financial entity, and it has to settle its bills before anyone gets an inheritance. The executor uses the estate's funds to pay for funeral expenses, any outstanding medical bills, credit card debts, mortgages, and other liabilities. This is why that creditor notice period in Step 2 was so important. The executor also has to handle taxes. This includes filing a final personal income tax return for the deceased person for the year they died. Additionally, if the estate is very large and exceeds the federal or state exemption limit, the executor must file a separate estate tax return, known as Form 706. Only after all legitimate debts and all required taxes have been fully paid can the estate move on to the next phase. We're getting close to the finish line with Step 6, the distribution of assets. Once all the bills are paid and the taxman is satisfied, the executor can finally prepare to distribute the remaining assets to the beneficiaries. But they can't just start writing checks. First, they must prepare a final accounting. This is a detailed report for the court that shows everything that came into the estate, everything that went out to pay debts and expenses, and what is left over for distribution. This final accounting is filed with the court for review. If the judge approves it, they will sign an order of distribution. This court order gives the executor the legal green light to transfer the assets, whether it's cash, property titles, or stocks, to the beneficiaries as specified in the will, or according to state law if there was no will. And finally, Step 7. Closing the estate. After all the assets have been successfully distributed to the beneficiaries and receipts have been collected to prove it, the executor's job is almost done. They file one last set of paperwork with the court, showing that all duties have been completed and the judge's order has been followed. The court reviews this final submission, and if everything is in order, the judge will sign an order formally discharging the executor and closing the probate case. At this point, the estate ceases to exist, and the executor's responsibilities are officially over. The process is complete. Now, I know that sounds like a lot, and you might be wondering how to make it go faster. There are a few key strategies for smaller estates that fall below a certain value, which varies by state. You might be able to use a small estate affidavit. This is a simplified process that can bypass full probate court entirely, saving a ton of time and money. The best strategy, however, is proactive planning. Creating a revocable living trust is one of the most effective ways to avoid probate. Any assets you place into the trust during your lifetime pass directly to your beneficiaries upon your death, no court involvement needed. If you're already in the probate process as an executor, being organized is key. Pay off major, undisputed debts early to clear them off your plate, and don't be afraid to ask for help. Hiring a professional, like a probate attorney or a CPA who specializes in estates, can be invaluable. They know the system inside and out and can help keep the process on schedule and avoid costly mistakes. Their fee is paid by the estate, and it's often well worth the investment. So, that's the probate process from start to finish. It can be a long road, but understanding the map makes the journey much less intimidating. It's all about following the legal steps to ensure everything is handled fairly and correctly. If you found this guide helpful, please smash that like button and subscribe for more legal walkthroughs just like this one. And I'd love to hear from you in the comments below which step of the probate process seems the most daunting to you. Let's talk about it. Thanks for watching, and I'll see you in the next video.